Major breaking news, and as predicted by this channel, the U.S. Court of Appeals for the Fifth Circuit out of Louisiana and Texas has found that the federal ban on 18, 19, and 20-year-olds from being able to acquire handguns from FFLs has been declared unconstitutional by a 3-judge panel in the Fifth Circuit. We're going to talk about this, and let's get into it right now. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment, winner of that in the 2025 Gun News Awards. Thank you for your support. I really appreciate it. I could not do it without you, the fans, and the subscribers, and the followers. Okay, folks, here's the story. Very, very, very good news today. And yes, this may find its way in front of the U.S. Supreme Court, and I predict we will win this one. Major win, as predicted, in the Reese case versus the ATF down there in the Fifth Circuit. We covered the oral argument when it occurred. I said we're going to win this case, and this will be a basis to go to the Supreme Court because it declares a federal, that's very important, a federal gun control law to be unconstitutional under the Second Amendment. This is a very big deal. Specifically, the laws and regulations that say that 18 and 19 and 20-year-old Americans who wish to acquire handguns, the most popular gun in America, who wish to acquire handguns from FFL's federal firearm licensees, may not do so. They have to be 21 years or older to acquire a gun from a gun store. The most popular and typical way you acquire guns in America is by buying it from an FFL, from a gun store. Hello, like everything else in America. Nevertheless, if you're an 18, 19, or 20-year-old adult in America, you are barred from doing so under federal law. That law has been deemed in the Fifth Circuit to be violative of the Second Amendment's right of the people to keep and bear arms. In a powerful decision, a unanimous 3-0 decision, written by a future, so she's no longer at this point, but a potential Supreme Court Justice, Judge Edith Jones. Very, very respected judge. Could have been on the U.S. Supreme Court, was qualified to be on the Supreme Court, did not quite make it because it's a numbers game. But nevertheless, Judge Edith Jones is highly respected by all people of all political stripes as a serious, earnest judge, an originalist, and has indeed found that this law violates the Second Amendment and runs afoul of the Bruin methodology that we've talked about before. A lot of important findings here, so let's get right down to it. To begin with, as you know, the federal law says you have to be 21 years of age to buy a handgun from an FFL. In light of that, the first question is, does a ban on the purchase of firearms from an FFL violate the Second Amendment? Is it even implicated by the text of the Second Amendment? Because as you know, under the Heller-Bruin methodology, we start with the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. If a modern-day gun control law or the proposed activity of the plaintiff would run afoul of the text of the Second Amendment, that modern-day gun control law is presumptively unconstitutional and unenforceable under the Second Amendment. And that shifts the burden to the government to demonstrate a long-standing, well-established tradition of firearms regulation that is analogous to the modern-day gun control law, which meant that today, assuming the text was satisfied, which it was, the burden shifted to the federal government, to the Joe Biden Department of Justice, because that's who fought this, to establish a well-established tradition that 18, 19, or 20-year-olds can be banned from acquiring firearms by buying firearms. That was a no-can-do. But let's just start with the text. The first question is the act of purchasing, listen carefully, folks, is the act of purchasing firearms, purchasing handguns implicated by the text of the Second Amendment? Because the text has to be implicated before the burden shifts to the government to do the historical spade work. And the court said, indeed, undeniably, as we've talked in detail about this channel, you've heard, if you follow the Four Boxes Diner, you literally could have written this opinion, by the way, but set that issue aside. They specifically said that, of course, that the plain text of the Second Amendment establishes a right to acquire handguns, to acquire firearms, because the right to keep and bear arms surely implies the right to purchase them. citing to a series of cases, including the Azell case out of Chicago and Clarence Thomas's famous line, "This is constitutional rights implicitly protect those closely related acts necessary to their exercise." In fact, not only have you seen my argument talking about ancillary or concomitant rights, and Ameland, when I've written for them occasionally, I've written specifically on this topic for them. I've also talked about concomitant or auxiliary rights or ancillary rights, really, on this channel. And that is exactly what the Fifth Circuit did here. They point out that the right to purchase arms, to acquire arms, is indeed part of the text of the Second Amendment. And therefore, because the federal government has hindered, restricted, in this case actually banned, one mode of acquiring firearms, handguns, from an FFL, that is an infringement because the right of the people to keep and bear arms shall not be infringed. If you look at the definition of infringed at the time of the founding, it means to hinder. To hinder. Well, obviously, if I say you can't buy guns from the most popular outlets in America, gun stores, I'm hindering your ability to acquire a gun. And if you can't acquire a gun, you can't keep and bear the gun because you got to have it in the first place. And that is exactly what the Fifth Circuit said here, that the text was implicated by this law. Then it goes on to talk about the people. And this is very powerful. And in some ways, this is a very easy question, but it was great that the Fifth Circuit analyzed this because some judges refused to follow the law. Specifically, they say that it is pretty clear, if you look at the text, the right of the people, that includes all Americans, because the Supreme Court in Heller says everyone associated or connected to the American community, really, and that obviously would include American citizens. And then they talk about a series of other constitutional rights where 18, 19, and 20-year-olds, and even frankly younger than that, but set that issue aside, that 18, 19, and 20-year-olds are all part of the people. They have the right to assemble. They have the right to vote, in this case because of the 26th Amendment. They have the right to enter into contracts. They have the right to be protected from unreasonable searches and seizures. They have the right to effectuate or invoke their Fifth Amendment right not to keep silent and not to incriminate themselves with government, and so on and so on and so on. So basically, the Fifth Circuit opinion here by Judge Edith Jones literally lays out all the different ways that 18 and 19 and 20-year-olds are protected and fall within the definition of the people for the rest of the Bill of Rights, for the rest of the Constitution. In fact, it basically says in light of that, it's very little doubt that the reference to the people and the right of the people to keep and bear arms includes 18, 19, and 20-year-olds as a matter of text, And in light of that, you have an infringement on the right of 18, 19, and 20-year-olds who are part of the people to acquire guns, which means their ability to keep and bear arms has now been adversely affected. It's now been hindered. And as a consequence, the text was satisfied in this argument. The government's modern-day gun control law doing this restriction implicated the text of the Second Amendment. And that means what? That means that the law was presumptively unconstitutional, and the burden then shifted to the government, the Department of Justice under Joe Biden and Merrick Garland, to show some sort of historical tradition of firearms regulation that would justify this ban on 18, 19, and 20-year-olds being able to acquire handguns from FFLs. And this is where it got even worse for the anti-gun movement and for the Biden Department of Justice, because when you start to look at the history, it gets much worse for them. Specifically, the court goes on to say that as a matter of just the text of the Constitution, we know that if the founding fathers wanted to age restrict some sort of right, they knew how to write it into the Constitution. They gave an example of the age restrictions of when you can run for and become a member of Congress. You can become a senator. You can become the president. There's specific age requirements. For example, you're not allowed to run and be elected the House of Representatives until you're at least 25 years of age. So the court says, obviously, if the founding fathers knew how to write age restrictions into the text of the Constitution, they certainly could have written it into the text of the Second Amendment if that's what they wanted to do, but they chose not to do that because they wanted the people to have the right to keep and bear arms and not some sort of limited subset. But then they go on and talk about some of the other history, specifically, and this is a big one, and I know what you're all going to say because you're all trained to immediately talk about this instantaneously when you're dealing with these young adult cases, and that is the famous on this channel at least, Militia Act of 1792, because the Second Amendment and the Bill of Rights was ratified, effectuated, went into effect in the year of our Lord 1791, and 5 or 6 months thereafter, what happened? You know what happened? The Militia Act of 1792 was enacted by Congress. And why is that so important? Well, I will tell you why it's so important, not because I say so, but because the U.S. Court of Appeals for the Fifth Circuit in this opinion by Judge Edith Jones tells you why it's important. Specifically, it specifically said that 18, 19, and 20-year-olds, frankly, 18-year-olds of age, all the way up to 45 years of age, had a duty to be in the militia, and that duty required, ready, you know what I'm about to say, which is that they had to acquire their own privately owned firearms, their own privately owned pouches, their own privately owned ammunition, their own privately owned cartridges, their own privately owned powder, among other things. In other words, it was expected, and not just expected, but demanded and required that 18, 19, and 20-year-olds, all the way up to 45, at the time of our founding, as of 1792, had to have their own firearms and weapons that they were then required to bring with them to militia musters as part of their obligations. But how on earth can 18, 19, and 20-year-olds be able to get the weapons, the ammo, the firearms they need to show up for militia musters when required if they're not able to acquire it in the first place? Which goes back to, obviously, the right of the people to keep their arms must, by implication, by necessary implication, must include the right to acquire firearms in all respects, whether it be making your own guns, purchasing your own guns, trading your own guns, whatever, inheriting your own guns, it doesn't matter. But at the time of the founding, they had to acquire their own guns at the age of 18, 19, and 20. So how can the government come forth with historical tradition of restricting 18, 19, and 20-year-olds from possessing firearms when it literally was a federal law that applied to every single state? Every single state, they had to actually show up with their own firearms. How on earth could they get their own firearms if they could not, among other things, buy them? Hello, McFly, this is not that hard. And that is exactly the point that Judge Edith Jones made in this case of Reese versus ATF Merrick Garland. Because this language from the Fifth Circuit is so powerful on the militia point and the necessary precondition to be in the militia, I'm just going to read it to you because Judge Jones says it better than I ever could. Let me tell you what she says here and right now. The 1792 Militia Act, passed shortly after the Second Amendment was ratified, required 18-year-olds to enroll in the militia, and militia members were required to furnish their own weapons. Of course, the right to keep and bear arms was not coextensive with militia service. However, gun ownership was necessary for militia service. Militia service was not necessary for gun ownership. Do you hear what Judge Jones just said? The gun ownership was necessary for militia service, but militia service was not necessary for gun ownership. Very important point to understand there. She then goes on to say, to satisfy its burden that banning 18 to 20-year-olds from purchasing handguns is consistent with our nation's historical tradition of firearm regulation, the government must overcome this clear and germane evidence that 18 to 20-year-olds enjoyed the same Second Amendment rights as their 20-year-old peers at the founding. Powerful language there. It's exactly what we've been talking about on this channel. It's exactly what I've been talking about in my law review articles, including, I think, in the Georgetown Journal of Law and Public Policy. So nothing new here if you've been watching the Four Boxes Diner. I should, while we're doing this, congratulate the Firearms Policy Coalition and the Second Amendment Foundation, as well as the Louisiana Shooting Association. Congratulations to those groups, as well as the individual plaintiffs that won this case of Reese versus the ATF and Merrick Garland. Congratulations to you all. And the only other point I want to make is this, and listen carefully to what I'm about to say. The anti-gunner argument that they always trot out in these 18, 19, and 20-year-old cases is this, that minors, you were a minor in many respects at the time of the founding until you were 21 years of age. You hear what I just said? Under 21 years of age was, in many contexts at the time of the founding, you were a minor. That is historically basically true. Okay? And by extension, the anti-gunners then argue, since you were a minor at the time of the founding until you were 21, we today in the 21st century can deny 18, 19, and 20-year-olds their right to keep and bear arms because at the time of the founding, they were minors. But there's several problems with that. I'm just going to give you one quick answer to this. Remember how I've taught you in the prior videos about how that language in Rahimi that says the law is not trapped in amber, and the anti-gunners think that's good for them? And I told you, it's not actually good for the anti-gunners. Okay? Sloppy poppy reasoning, in my opinion. The language in Rahimi that says that the law is not trapped in amber is actually good for the Second Amendment. It allows, for example, modern-day protections of modern firearms under the Second Amendment, even if those firearms did not exist at the time of the founding. The extensions of those protections continue into the turn of the 21st century, even if, technically speaking, they might not have existed in the 18th. That applies here today. Hear me out. Let us assume hypothetically, at the time of the founding, that 18, 19, and 20-year-olds were minors and could not acquire guns for the sake of argument. That argument would not justify barring today in the 21st century, 18, 19, and 20-year-olds from being able to acquire and own guns today. Why? Because today in the 21st century, 18, 19, and 20-year-olds are full-blown adults. They can have abortions, they can get tattoos, they can enter into contracts, they can get married, they can change their gender, they can join the military, and on and on and on, right? And they can vote under the 26th Amendment to the U.S. Constitution. So even if you assume for the sake of argument that minors could not have guns and were not full-blown adults at the time of the founding, because the Supreme Court said in Rahimi that the Constitution is not a law trapped in amber, that means by extension, since today 18, 19, and 20-year-olds are considered full-blown adults for all purposes and not minors, right? They're not minors. Guess what? Today, 18, 19, and 20-year-olds can have a full-blown right to keep and bear arms, even if arguably they could not do it at the time of the founding, because today they're considered full-blown adults in a way that maybe they were not at the time of the founding, but because society now views them as full-blown adults, they get all the full-blown adult protections. And by the way, just as a public policy matter, it is absurd to think that 18, 19, and 20-year-olds cannot have the right to keep and bear arms when the reality is you're usually financially poorest and least sophisticated when you're young, which means you're probably going to be staying in homes, apartments, places that are a lot less safe when you're young than when you're old and have had a chance to earn money and learn about life. So if anyone is getting the late night shift from midnight to 5 in the morning at the hospital or on the job site, right, you get the crappy shift when you're the kid, you're the low man on the totem pole, the low woman on the totem pole, right? These are the people that arguably need the greatest protection because they're the ones going home at night or going to work at night in the most dangerous parts of town, the least safe, arguably, right? They can't afford all the fancy stuff that older people can possibly afford after they've had a lifetime of earning, and so on and so on. So it's really wrong, in my view, to deny 18, 19, and 20-year-olds the ability to defend themselves with a firearm, given in many instances they are at the greatest risk of being victims of violence versus, let's say, a much older person in a much safer part of town or in a much safer part of the country, because they can afford it, and young kids can't afford it because they haven't had the chance to earn money or develop an income, and so on and so on. So there you have it, folks. But the bottom line is a huge, huge, huge win in the U.S. Court of Appeals for the Fifth Circuit. What interesting question is going to be is, will the Donald Trump Department of Justice seek cert in this case or not? There's a lot of considerations there. We'll cover that in a future video. But for now, be happy. We kicked butt as predicted on this channel in the Reese case, and I've been saying this potentially is the next U.S. Supreme Court case, and this is a great one to win because it will help vindicate and reaffirm the existence of the Bruin methodology, and the Second Amendment is not a second-class right. So keep up hope, folks. The war is on, and I expect to win this one for our right to keep and bear arms and the rest of the Constitution as well. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to follow me and subscribe to both Rumble and YouTube. And I look forward to talking to all of you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.